can get started. It's 12:30. My name is Alex Zhang. I'm the Associate Dean for Information Services at the Duke Law School. And it is my great pleasure to welcome you all to our Faculty Author Book Talk series. First, I would like to thank Professor and Associate Dean for Intellectual Life, Gina Gill Fletcher, and her office, and she's just sitting, for sponsoring the lunch. And we all know that sometimes, and probably at all times, the most important part of our intellectual life is a well-timed lunch. And I also wanted to thank our IT colleagues, our media services colleague, and my wonderful partners in the library, Jennifer Behrens and Shauna Bangrome. Today, we're here to celebrate Professor Marin Levy's new book, Written and Unwritten, The Rules, Internal Procedures, Customs of the United States Court of Appeals. Professor Levy joined the Duke Law faculty in 2009 and received the law school's Distinguished Teaching Award in 2017. She currently serves as the director of the Duke's program in public law and is the faculty director of the Boach Judicial Institute. Professor Levy is also an elected member of the American Law Institute. We're also very fortunate to have Professor John Petkin moderate the conversation today for us. Professor Petkin is an MIT-trained economist and a Yale Law School-trained legal scholar. Before joining Duke Law faculty in 2022, Professor Petkin clerked for the United States Court of Appeals for the DC Circuit. We're going to dive into the conversation about this book in a second, but I want to highlight a very important detail about the book, and that is the foreword of this book was written by a former U.S. Supreme Court Justice, Justice Stephen Breyer. And here is just a preview of what Justice Breyer had to say about this work, and I quote, "A book that fills a void that will produce better appellate rules and practices, and which will greatly improve the federal system of justice." And at the end of the foreword, Justice Breyer noted, and I quote, "We all, judges, lawyers, and members of the general public, owe the authors a debt of gratitude." So after hearing this, I hope you are just as eager as I am to learn all the fascinating insights about this book. Now, without further ado, please join me in welcoming Professor Levy and Professor Petkin.
We can just go home. We're good.
I am so excited to be here with y'all to celebrate Professor Levy's remarkable achievement with Judge Newman. I think it is rare that you can pack a house for an event about the courts, but I love that here at Duke Law School, it's almost a given that would be true. And I think anywhere Professor Levy goes, the same follows.
This is all you.
So, without further ado, we thought we would have a little bit of a conversation about the book. This would be a little bit less of a book talk and more of a book fireside chat sort of thing. And so I kind of just wanted to start with the basics. Professor Levy, if you don't mind telling us, just describe the book if you would, and how did you and Judge Newman come to write it?
Terrific. Well, first let me just echo the thanks to everybody in the library and Jennifer Behrens in particular, and the Dean's Office for sponsoring this. It is such a lovely tradition that we gather like this and talk about people's scholarship. So thank you. And thank you very much to Professor Petkin for taking the time to do all of this, and for you for being here, including my parents who are sitting in the back. I can't help but acknowledge it. So what exactly is this book about? I was thinking about how to describe it, and this is what occurred to me. So I don't know if you all had this kind of experience, but I remember growing up coming across a kind of staggering statistic, which is that something like 95% of our oceans are unexplored, which seemed like such a shocking figure when I first learned that, right? You think, we send people to the moon, and yet there's so much in our own backyard that we don't even know about. And as it turns out, kind of surprising though it sounds, there's a similar story to be told with the federal courts, and in particular with the federal courts of appeals. Those are the courts that I study. So I know everyone in this room will appreciate just how important those courts are. So when we talk about the federal courts of appeals, we are talking about those 13 circuits, right, the intermediate appellate courts. So those are circuits 1 through 11, DC and the federal circuit. Right, 179 active judges, and together they are deciding every year upwards of tens of thousands of appeals. Right? Now we can contrast that with what's going on at the Supreme Court. As we know, the High Court is deciding every year fewer and fewer cases. I think last year it was even south of 70. Right? So it's really the courts of appeals that end up being our courts of last resort in this country. So given how important they are in the federal judiciary, and given how important they are really in our country, you would think we would all know, right? And certainly the courts would know about each other, how they operate. Right? So what exactly happens when an appeal is filed, right? Oral argument, the publication of an opinion or not, that we would know all of these things, that we would know things like, how do they govern themselves? Right? Do they have committees? And if so, what kinds of committees? Who's staffing those committees? Right? They have things like circuit councils. Who's sitting on them? Who's picking who's sitting on them? You would think that we would know all of this. And it turns out that we don't, generally speaking. Right, so I first came across this fact when I was clerking some years ago. And I first realized that, in fact, a lot of cases are decided in the Second Circuit without oral argument. One of the first things I asked when I learned about this was, well, what are the procedures here and how do those compare to what's going on in the other circuits? Right? Like what's happening in the First Circuit? What's happening in the Third Circuit? Does this line up or is there variation? And the response that I got consistently from the judges I spoke to was, like, we don't know. Like, we don't know what's going on in the other courts, right? Like, we're busy, we're doing what we do here. It's hard to keep up with all the rules in our own court, much less what's happening in the other circuits. And it was then that I heard this line that has stayed with me ever since from a clerk of court, which is that what we don't know about each other far exceeds what we do know, right? Which proved to be true. So part of that is because, as it turns out, a lot of these practices, norms, and customs are not written down. And part of that is because even if they are written down, they're really hard to find out, right? And not a lot of us are so keen to go looking. So it was because of this that Judge Newman and I got together and thought, this is really a missed opportunity. Right? This is information that should all exist, and it should exist together. And so we decided to write this book. And so what this book is, kind of, you were to look at it all together, the majority of it really walks you through the life cycle of an appeal within the federal courts. Right? So there are chapters devoted to each critical moment. So we talk about briefing, we talk about oral argument, we talk about the writing of opinions, and then what happens when you have opinions that aren't published, right? Shorter orders. We talk about in-bank procedures, right? Within each chapter, working through exactly what's going on in these different circuits. And then at the end of all of that, we talk a lot about the governance structures, right? So what are the different committees? What's the role of the chief judge in each of these courts? Right? Again, the circuit council, what it's doing, how that variation looks across circuits. And so the hope is that we have essentially a comprehensive guide that we are handing over that's meant to cover all of this information. So it's not a beach read. I should make that clear.
For me, it is.
Bless you.
I love this idea of thinking of Marin Levy, deep sea explorer.
Jacques Cousteau, yeah.
Yeah, I think I would go for like law professor astronaut personally, but so I would never ask you, of course, to betray the sacred trust between co-authors, but I do think it's remarkable that you have several times now co-authored with judges. Would you mind telling me a little bit of what's that like?
The kind of underneath their robe, yeah, all of that good stuff. Yes. So maybe I'll answer something slightly different first, which is to explain why I've done so much co-authoring with judges. I think when you work in this space, it's almost necessary to team up with somebody who is inside, as it were. I think for a couple of reasons. So one is there is so much to each of these institutions that you need to have some way of accessing that. I think a little bit like if you were to visit a foreign country and to try to study it and talk about it, like you need a guide who speaks the language, right? So that's a big part of it. The other part of it, quite honestly, has to do with access. So a lot of these projects, as you could probably tell, rely upon things like interviews and surveys, right? You actually have to talk to people to understand what's going on in these institutions. The judiciary is a notoriously guarded institution, and so working with an Article III is a great way to have people open their doors. So we were very lucky with this project. We had a 100% response rate All the judges we hoped to talk to, we were able to talk to, and ditto with the clerks of court. So that's a little bit why I think it's necessary for an academic to pair up with a judge for these kinds of projects. In terms of working together, so I think we have bonded over the years over our shared love of judicial administration. There are not many people out there who can say that they love the technical details of courts the way that we do. And after all these years, I think we're like an old comedy duo at this point. You know, it's like, oh, you're going to want to put this in, you're going to want to take it out. You know, I think we've enjoyed the process quite a bit.
Wonderful. So to return to the deep sea analogy a little bit, so you mentioned that you perceived a void in this literature, in this area. I imagine if I were setting out to explore the oceans, I wouldn't know how to begin to go about doing it. Similarly, how does one study the courts? And so you mentioned just a moment ago, 100% response rate. I take it there were a lot of conversations here, a lot of different things you did to gather this information. Can you tell me a little bit about how did you go about writing the book?
Yeah, it's a great question. So I think particularly for the students here, when we talk about legal research, so often we're talking about engaging with written texts, right? So whether we're talking about reading cases, reading other law review articles, right? Reading statutes, going into archives, like so much of what we do is based on written sources. And so then the question comes up, what do you do if those sources don't exist or they don't kind of take you all the way that you need to go with a particular project? So this is when you rely on qualitative tools, in particular interviews and surveys, and we used both for this project. And I would say we really did this in phases. So the first phase was we conducted what we call semi-structured interviews of all of the chief judges of all 13 courts of appeals. So those were fascinating conversations. Some of them lasted upwards of 2 hours. We get some rules nerds talking and we can get pretty chatty. But that we thought was really a critical first step in just understanding what was going on in each of these courts. From there, I would say the second phase was we spent a whole lot of time in the rules of each of these courts. Right? When I say rules, I'm talking about the circuit rules, the internal operating procedures, the general orders, the standing orders. Right? And what you quickly realize is it's like each court is its own country. And so when you work your way into these sources, you kind of have to get oriented and realize, okay, actually in this circuit, this is covered in a guidebook, right, which other circuits don't even have. So you start to realize where all this information is stored. From there, what we did was we then sent detailed surveys to each of the clerks of court about specific questions of judicial administration. But even that was not the end of that process. That ends up being iterative, in part because you run into the following. So we would ask what we thought was a pretty straightforward question, a survey, like in your circuit, do you do X or do you do Y? And you would get some responses where people would say, well, we do X. Some would say we do Y. And then some people would write back and they would say, well, we say formally that we do X, but actually in practice we do Y. Or some people would say something like, yeah, we do X some of the time, but actually some of the time we do Z, right? So that's a little bit of a wake-up call, and what that means is that you're going to have to go back to all of your sources and then say, great, let's drill down with that. As a follow-up, have you ever done Z? Or, you know, what are you doing in practice versus what do you say your rule is? So we went through that round as well. And then I would say the final round really was this. So what we worried a lot about, what I worry a lot about is the kind of unknown unknowns. Right, so all of the moments where you may not even know that you are missing something. And so because of that, once the manuscript was complete, we then sent it to every clerk of court, and all 13 clerks responded with comments. Bless them. We changed the draft accordingly, and we had changed it enough that I thought we needed to do it again. And so we did it again. So we then sent it back to all of those clerks. And again, this is just a credit to them. They all read the book and gave us comments back. And so that was what we did. If I could say maybe just one more thing to kind of step back. So as you can tell from what I've just described, the output here really is largely what we would call descriptive work. Right, so there's a little bit of a, you know, we have some prescriptions along the way, but largely what we're doing is just describing, providing what we would call rich descriptive analysis of the courts. And I think it's important to highlight that because when we talk about legal scholarship, so often, I think reflexively, we fall back on certain questions, right? Questions like, what's the big theory here, right? Or what's your normative take, right? Or who are you in conversation with? Questions that I think are really, really important, but only apply to a subset of scholarship, right? And it's important, I think, to keep in mind like where you are in the trajectory of a field. Judicial administration is a really young field, and at this point, so much of the work that needs to be done is that kind of information gathering, right? It's like that kind of foundational work, in part so that you can set up future scholarship where you get to engage in these other questions. So it's not so much that we are, say, in conversation with a lot of people, we're really trying to start a conversation.
Wonderful. If I can pick up on one thread there, you had mentioned the clerks of the court, and I'm not sure all of us are familiar with this office of the clerk of the court. I take it these conversations were very important, and they were able to share information that maybe the Article 3 judges couldn't. Who is the clerk of the court?
Yes, this is a great question. So within the court, we tend to see really the judges, right? Those are the public-facing figures, but there are dozens and dozens of staff working behind the scenes. And one of the most important figures in that story really is the clerk of court. So that is the person who is in charge of the cases the moment that they come in. They are in charge of docketing. They are figuring out how they're getting assigned, where they need to go, right? The clerk of court, depending on the circuit, is actually empowered to decide certain motions, right? So you want to extend time. You want to have a lengthier brief, right? That person is making the call. But it's even more than that. That person is sitting ex officio on a number of committees, right? They are seeing the running of the court, library, technology, right? Working basically side by side with the chief judge just to make sure that the cases are running and really engaged in the case management of each of these institutions.
And so with some books, there's often sort of an audience in mind. But based on how you've described the project so far, I can imagine that there might be many audiences for this particular project. You have, of course, the public who just don't know enough yet about our courts. Maybe some of the judges themselves, the legal profession, scholars who maybe will be able to develop other analytic or even normative takes based on what you've now shared with us. So can you talk to us about the different audiences maybe that you saw with this project?
Yeah, so I love that. So absolutely, this is a somewhat unusual project in that we have multiple audiences in mind. So starting small and getting big, I mean, to some extent, we're thinking about practitioners, right? So if you are out working across the country, filing cases in different circuits, the thought is it might be helpful to have something like this. It would certainly not substitute for consulting with the individual rules of any court, but getting to those kind of unknown unknowns, it might be helpful to realize like, oh, actually there's variation when it comes to, right, like I'm filing a motion for a rehearing, but also rehearing in bank, right, that there are differences across the circuits on these practices. I think much more so we're really thinking about the academy and we're thinking about the bench. So in terms of the academy, so as we were talking about before, I see this book in some ways almost as a collective research agenda, right? That you can look at this variation, and I've recently been having conversations with empiricists not as good as you, right? Who think about variation and then want to study its effects. And I'll give you an example of something that might seem really trivial, but why this ends up being important. So as you all know, right, cases, when they're argued, are almost always argued at the Court of Appeals before a 3-judge panel. And then there's an interesting question about when you're going to reveal the identity of the panel members. Right? And you can see the different takes on this. So there's some who think, well, if we, the court, know who's going to be deciding the cases, we should let the public know as soon as possible. Right? We should be totally transparent about this. And so you have the DC Circuit, for example, that lets the parties know 30 days out, this is who your panel will be. On the other extreme, you have courts that think, if we reveal who the panel is quite a bit of time ahead, right, we're worried about a couple things happening. So one is we might see a spike in settlement, right? Somebody will say, oh, there's just no way that I could possibly win when it's this panel, so I might as well just settle. Okay. The other thing people, I think, worry about is then you're going to see litigants pitching to certain judges, right? So now that I know, right, that Judge Frakes is on the panel, I'm going to be citing his cases and really trying to argue to him, and that might not actually be a good thing necessarily for the law as a whole. right? And so you have courts like the Seventh Circuit that don't reveal the identity of the panel members until the day of. Right? So that's really interesting variation, and there's a lot that sort of sits in between that. It's the kind of thing that would be really fun, I think, to study, right? There hasn't been, to my knowledge, any sort of detailed analysis of this, but you could look in the circuits where this information comes out far ahead of time. Do we see an increase in settlement, right? And now we have the ability to look through, say, transcripts of oral argument, and you could see, right, are people pitching their arguments more towards certain judges? Are they citing the opinions of those judges much more in those circuits where this information is known way out? Right? So again, the hope with a book like this is actually that folks can come along and say, here are variations that seem interesting. What can we do with that? Let's actually study what the effects are of that, with the hope that also that could be useful to the courts. And then now thinking about the courts, it's not, I think, so uncommon in our profession that you see academics writing to courts, but so often that is done in terms of substantive law, right? So law professors will be writing articles and maybe even filing amicus briefs with the idea that we're trying to sway the opinion of a justice or a judge. What is far less common is to see this when it comes to procedure and really kind of practices of judicial administration. But I would say very much, right, what Judge Newman and I are hoping to do is to let different judges know what these practices are out there, precisely so that the judges themselves can think, oh, it hadn't occurred to me that we could do this. Maybe that's something we want to try.
Wonderful. Certainly from the scholarly vantage point, I think us empiricists owe folks like Professor Levy such a debt of gratitude. In some ways, the empirical work is often the easy part. The hard part is finding these sources of variation and identifying the really interesting questions in the world to answer. So thank you for giving me like a gazillion papers to write one day. So stepping back a little bit, this book feels almost part civil procedure, part federal courts, but I think we might also label it under a slightly different header of something like judicial administration, which is a much younger field, I take it. Can you tell us a little bit of what does this field of judicial administration encompass? What do we mean when what are we talking about when we're talking about judicial administration? And where do you see the field going?
Yeah, I love this. I feel like we could write a musical on this, So you're absolutely right. So what we're talking about here is, I think of as a new and growing field called judicial administration, right? So that's a field of scholars who are interested in questions about how the courts operate, right? So it's not so much thinking about substantive law. It's not even so much thinking about procedure in a formal way, but it is thinking about how do the courts run day to day. And the idea being that that's important in and of itself, and we might care about that for fairness considerations or kind of process values, but also then because it ends up affecting the outcomes of cases. So 50 years ago, Chief Judge of the Second Circuit, Wilfred Feinberg, wrote that judicial administration is the stepchild of the law. That's a kind of ringing endorsement. And he said at the time, that kind of inattention seems odd, given actually how important so much of this is. I think since then we've seen a real shift, and in particular in the last few years. So some of that is because of the scholars who have joined the field. There are a lot of more junior folks with a lot of energy who are really excited to be writing in the space, people who have maybe a foot in con law or civ pro or fed courts, but who have come together to really think about the courts as institutions. It's also, I mean, you think about the issues that are grabbing headlines. Think about the shadow docket, right, at the Supreme Court. That's very much a matter of judicial administration, right? So how is the court deciding these cases? Is it deciding them in an expedited fashion? What kind of process do the parties get? You think about the judge shopping debate that is happening right now at the district court level, right? This is, of course, the problem that happens when you have districts that divide up into divisions, and you have only, say, a single judge in a division, and then that court has a rule that if you file in a division, you get the judge who sits within that division, right? Thereby basically allowing judge shopping. That conversation that's taking place right now is all a matter of judicial administration, right? So as an observer of it, but also a participant in this field, I would say, I think this is a really exciting time for it because it is growing. And can't help but plug Duke in this. I think that we're this year having our 7th roundtable on judicial administration. It's exciting to be at a place that is really part of kind of building this field, right? I think we've been trying to do that, very much kind of contribute to that. So anyway, I think this is a field that is growing, and I hope that this book can be a part of that process.
Focusing a little bit more on the content of the book itself, you've mentioned once or twice this idea of federalism, and certainly reading the book, it becomes very apparent that the 13 circuits are doing things quite differently in some instances, sometimes on matters really essential to appellate practice. And so should we think of this as a good thing, this lack of uniformity? And then relatedly, can you think of any instances where the courts are sort of learning from one another? Is that a good thing?
Yeah. So this question about uniformity versus variation is such a hard one to tackle, and it goes back to, I think, kind of first principles, not just with the courts, but really, obviously, with our entire governance structure. The way that I've come to think about it is not necessarily that variation is a good or a bad thing, but it's a necessary thing. And I think it's also important to recognize that this is not just the courts themselves creating variation, but some of this actually comes deliberately from the shared power structure that is in place between national interests and local interests. And I'll give you an example of that. So as the courts grew in size, meaning in terms of the number of judges, there was a concern at one point that they were going to be so big, right, that it would be hard to have an in-bank with all the active judges. Right? Can you really put, say, 29 people in a room and have them hold a single oral argument? The shorter answer is no, you can, right? So Congress then passes a law that says if you have a court of appeals that has more than 15 active judges, you can have limited in-banks. And you can determine how you're going to do that by local rule. Right? So that's really interesting. So that's Congress telling the courts, we are giving you permission first to decide if you even want to do this to begin with, right, once you're past this threshold. But then second, we're going to let you decide how you're going to go about doing it if you decide to do it. Right? And so what is the system that we have? There are currently 3 courts of appeals that are big enough that they could qualify for a limited in-bank. Only one has opted to do so. That's the Ninth Circuit. Right? And the Ninth Circuit has actually experimented over the years with how they're going to do it. Right? First, they decided to have 15 judges hearing cases in bank. They're now down to 11. Right? So that's an example where we have variation. And we have variation because of something quite understandable, which is like differences in the size of the courts. But also what's really interesting is that that variation has been not just kind of sanctioned, but basically invited, right, by Congress. So I think, a lot of this is actually this complicated dance, not just between the circuits themselves, but between the circuits, say, and what's happening on the national side, whether that be Congress or that be the federal rules committees. Now, in terms of variation, and do we see changes? So yes, we see lots of that, and I think that's an exciting space, and we hope that the book will bring about more of that. So my favorite example on that comes from the DC circuit. So something that you hear about a lot in the courts is that the most difficult part of the job for a chief judge is making sure that one's colleagues are getting their work out on time. Right? This is a notoriously difficult job for chief judges because they don't have many carrots and they don't have many sticks, right? I imagine this is just like being a dean sometimes with some colleagues who are not cooperating. Like, what can you do? So the DC Circuit actually came up with a great way of handling this, which is they decided as a court, if you are more than 2 opinions behind, meaning you haven't circulated these opinions, by the time we hit August, you are not going to be put on the new argument calendar come September. You actually won't be allowed to hear cases come September. Right? That's actually a pretty big stick when you think about it, right? Because then your colleagues are going to notice, the public might even notice. And so this was something that we reported, and we were sharing this with some of the chief judges, and Chief Judge Katzman at the time of the Second Circuit said, that is a terrific rule. I want that in my court, right? Because he knew all too well what it was like to be knocking on doors and saying, that opinion, is it coming out anytime soon, right? So that's an example where we had variation not based on something like size, not based on something external, where actually you could then have borrowing and uptake. And we were seeing some judges think, oh, let's try that in my circuit.
I worried that would not work at a law school if Dean Abrams said, if you don't get your grades in on time, I'll give you less grading to do. Probably some perverse incentives there. But I also love that you used bank practice as a source of variation because it's so varied we can't even agree how to pronounce it.
You say in bank, I say en banc, right.
So I did want to move and talk a little bit about who is behind all of this stuff. So when we say judicial administration, I take it the judges themselves are responsible for a lot of judicial administration, maybe not solely responsible. Can you tell us a little bit about who are the players here and how should we think about the who of this?
Yeah, the who is such an interesting question, in part because there are many people who fall under that heading. So when it comes to these sorts of things, there are a lot of different decision makers. And something that struck me recently, a chief judge of a court of appeals said, when it comes to rulemaking or norm developing, these kinds of things, he said, this is such a fun space for many of us because it's the only time we really get to engage in policy making. Now, of course, we in a law school might roll our eyes just a little bit. We might think, what's going on in opinions every day, right, guys? But I think that as a formal matter, he is right in the sense that, this really is policy making, right? This really is the judges deciding how they're going to govern themselves and the adjudication practices of their courts. That is an enormous amount of power that we hand to them, and it's extraordinary when you think about, in some ways, how little transparency there often is around these practices. Okay, so now the question is, right, where are these different rules coming from? So some of the rules are coming from, as we mentioned, Congress, right, or of course the federal rules committees, which are incredibly important in all of this when we're talking about these courts. Really, we're looking at FRAP in particular, right, the Federal Rules of Appellate Procedure. So we have a committee that is appointed by the Chief Justice of the United States. They meet on a regular basis. They update their rules by amending them, right? So there is that happening in the background. One level below that, you have then the circuits themselves. And each of the circuits has its own rules committee. Some of them then have advisory committees. So they are thinking about what should the rules of the First Circuit be, or what should the local rules of the Ninth Circuit be. And they have procedures there that map onto what's happening at the national side. And so they go through notice and comment and all of that good stuff. Where I get a little bit more nervous is that some of these rules are really coming from individual judges, and there is not much oversight when it comes to those, and there is no public input. So thinking about that perennial problem of a colleague who is late with his or her work. So one judge we spoke to said that he handles that by when he is sitting and he is presiding. It's the prerogative of the presider to assign opinions. Right? And he says, I don't assign opinions to colleagues who are behind on their work. So maybe that makes a little bit of sense, right? It's not so different from what we were talking about as a court-wide rule, but notice that's not coming from some bright line, right, where all of the judges have agreed to it. This is an individual judge who's basically deciding after a given week, this person's not getting any opinion assignments, right? Again, it's not really transparent. It was not at all clear based on the way that he was describing that his colleagues were aware that this was a practice of his. And again, one might wonder, are we applying this evenly, right? Does it ever come up that there are judges who you say, well, you're behind, but I'd really like to hand this opinion to you anyway, right? And like, who is getting that benefit? So this is all to say, when we're thinking about the who, there are a number of different actors in all of this. And some of them, when they are making these rules, have a lot of process and transparency. Some of them do not. And it's the latter set that I tend to worry quite a bit about.
Well, I think that is such a powerful thing about the book is at least telling us sort of what do we not know? What are the less transparent parts? At least we know that they exist now. So thank you for that. I wanted to maybe open it up to the audience soon. I wanted there to be some time for questions. Would that be okay?
Terrific. Yes.
Wonderful. So if folks have questions for Professor Levy, I would love to take them. Yeah, please. Do you want to maybe say your name and if you're a student, maybe your class here?
My name is Madeline. I'm a 2L. I was wondering if there's a tension in asking people to disclose rules that aren't written down, and maybe when they say them out loud, they don't sound so great.
Yes, attention for them or attention for us? Yes. So it is certainly the case, right, that what we're trying to do with projects like this is learn things that, as we said, right, are not written down. And oftentimes they're not written down for a reason, right? The courts are not generally keen to have a lot of scrutiny placed on them, I think just for fear of being criticized quite a bit. So certainly it's the case that you might be worried when you're conducting these interviews that you're not getting a fully candid answer. And that's just something that you have to accept, right? That's a limitation of this particular methodological tool. There are different techniques that we use when we're conducting interviews that try to get around that. And you can say things like, my understanding is that this is a practice in this circuit. Like, does your circuit do that also? I mean, that's a way of kind of reassuring someone, like, we're not asking you to go out on a limb here, right? There are other circuits that do this too. In terms of, from my perspective, every time we interview somebody, we are giving them full anonymity. Right? So we're not quoting anybody by name. We're not saying, it's this particular person who has revealed this information. So we're giving them that cover. I think the way that I come into this is really where we started this conversation, right, which is we're talking about such an important institution within our country. I actually find it shocking in some ways that it takes two people a few years to gather all of this information. Like, this should all be public information at the start. It should be easily accessible. That's where I come at this from. And I think I would say that about the Supreme Court and about district courts as well, that there's a lot more that we should be doing in terms of opening up these institutions. So I myself, though I, might appreciate these individuals, my general view is, like, for the benefit of the public and all these different audiences, this information should be out there. It's a great question.
Sure. Professor Farahani?
I know you.
Well, so on that, without divulging more than you should, given your co-author, and given that you might have come across things that might have brought scrutiny in ways that some members of the court might not have liked, were there things left on the cutting room floor that either one or both of you felt like, in order to be able to have a 100% response rate in the future, in order to be able to open up a dialogue in a field, that there were some things that could not get said?
This is a great question. And so I think about it in two different ways. So to the specific question, was there anything that we didn't end up including in the book because it was a little too spicy, perhaps? The answer is not really, though there's one exception. And part of that is because a lot of these practices actually, though, I think we find them fascinating, they are actually not the sort of thing that a lot of people are going to jump over, kind of jump all over and say, like, how could the court be doing this? That's less true of other work that I've done. There have been other projects that I've engaged in that then made the courts look not quite so good, and that was a different story. There was one example where a chief judge had said to us in his court, right, when somebody is behind, he basically removes them from a kind of wheel where they would get various assignments, and then he later walked that back. And that's a hard kind of situation for a researcher to be in. We tried to triangulate that with other folks at the court who wouldn't do that, and then we felt like, okay, at this point we have to cut it. But I would say that's really the only example, the only time that came up, and that makes sense. That is a more sensitive subject for that court. And the larger point that you're raising is a really important one, which is that when you're in this line of work, you're dealing with a set population that you study. You may think from time to time, like, this is a repeat game, right? I would like to come back to these individuals and study them again and again and again, right? And so that may creep into the recesses of your mind, and I think it's really incumbent upon folks who do this kind of work to try to push that aside as much as possible. What I have found over time with judges and clerks of court is that they really are happy and respect people who they think are trying to do serious work and not just take pot shots at the court. So I think I've been lucky in that respect that I've been able to go back to people, but it's something, I think you have to take quite seriously. And, do I think this is a valid criticism? Yes. Does it belong in there? Yes, right? Even if that means I might lose a participant in a future study.
Professor Benjamin.
So,
Hey, Stuart.
So we talked about when I was doing research, but I've never seen this question about how often, or if you found cognitive dissonance when talking to judges. So to give an example, I don't know if it's in the book, but I know in your scholarship, when you found that on some courts, they all say they have random assignment, but it turns out, oh, well, actually, we always want to make sure that a relatively junior judge gets to preside early on, and so we will configure the assignment such, well, that's not randomness anymore. I know that great research, but I don't know if they nonetheless didn't see it that way. Like, that's a small example of some situation in which any outside observer would say, well, you say you're doing X, but quite obviously you're not doing X. The way you're even X might not be huge. It isn't like you're cherry picking the panels, but you're not actually random, or whatever the other example is. Did you find that sometimes where people simply didn't, like in that example, they just wouldn't have accepted that was not random, that they treated that as, and again, I'm using that as an example, and probably lots of other things, this might have come up in.
Yeah, so it's a great question. And I would say with this particular project, we didn't come across quite that phenomenon, right, where you would say, you're holding yourself out as doing X, but I think to any audience, we would say that's Y, and can't you see that there's a disconnect there, right? That said, I do think, and this is just what happens when you're interviewing people, right, that there were times when there were real disconnects in terms of what they thought they were doing and how we were perceiving them. Right? I mean, the judge that I described, it's actually a chief judge who was saying, oh yes, right, like I just don't assign certain colleagues' opinions and things like that. He was saying that in a way that, like, this is obviously the right thing to do. And I was thinking, are we hearing this in the same sort of way? And there were other examples like that. One question that we asked that we both really were interested in of the chief judges was, how often do you decide something by yourself, and how often are you consulting with your colleagues on the court? Right? These are really interesting, almost like a jurisdictional question, but it's more than that. This is really about, do you feel empowered to make some of these decisions about what the rules are, and do you feel instead you really need to be talking, getting buy-in, right? This is something like a dean would be facing. There were many, many thoughtful chief judges who said, I realize that I technically have this power, this authority, but I will be consulting with my colleagues, absolutely. But there were a few who very happily said, no, I would decide this completely on my own. And that was really interesting to be observing, right? I mean, I feel like when you're conducting these interviews, you're trying to absorb the information, and you're trying to be critical of it in that moment, but reading it back and kind of sifting through it, it was interesting thinking about those sorts of things. Yeah.
Wonderful. Professor Cox.
So I was curious whether within individual circuits or any circuit, they have procedures, protocols, or even heuristics within the circuit to decide whether an issue merits a rule that's going to be binding, whatever the practice is as far as it's concerned. I mean, what it seems I'd be hearing here is that there's a terrific amount of discretion, likely unreviewable, in the chief judge of the circuit. I was wondering if internally there's a way of individuals who are members of that court from raising an issue, and if they do, are there sort of accepted protocols for them to do that? And secondly, are there heuristics that get applied, much like the Supreme Court does on cert?
Yeah, so this is a really interesting question. Right, sort of at what point does something rise to the level where a court decides that it is worthy of a rule? So there are practices across all the circuits that speak to this, where a judge, say, in a quarterly judges meeting can say, we've been running into this particular issue. It seems like it would be helpful if we could have a rule on this, right? And oftentimes what will then happen is that is then sent over to the formal rules committee that will take it up and go back to the chief judge about it. There's back and forth, and the court as a whole has to sign off on any new rule that is then going to be implemented. So there is a formal process by which that can happen. But to the variation point, something I think is really interesting across these courts is there's actually variation in terms of the philosophy about the place of rules. There was one clerk of court who really helped not too long ago her court to pare down the rules. And her view was we actually just had too many, right? That the more rules you have, the more this is just a tax on practitioners. And it's so much better if we have more play in the joints and we have discretion that we're handing over to the judges, that they can decide in any particular instance, yeah, we're going to grant the motion, or we don't need to have a formal rule on that. That's really interesting, I think, right? And you can see why there is variation on this sort of thing, right? There are other courts that felt like, no, but if you're making these decisions, it's really important that we be transparent about it. It's really important that parties have notice about what we're going to do. So we should have more rules, right? Even if that means at some point the rules themselves become a little bit unwieldy, but that, better to have it be open and transparent. And something that was really fun about the project afterwards was some of the clerks of court saying, having read the drafts, it's really interesting to see the different approaches to rulemaking, right? And like, what is that sweet spot? How much should we be saying, this is really the way that we do things, and how much should that be in a custom and a practice and a norm, and picking up the kind of lessons from different courts. So this is all by way of saying, formally, there is a process for individual judges to try to have something percolate up. But in the background of all of that, there are just different philosophies about how much should be ruleified and how much should be left open, which is not corresponding to things like the size of the court quite so much, but really just the kind of temperament and the philosophical views of the judges themselves and the clerks of court.
Professor Cox's question gets at such a fascinating issue, and if I can just use this to plug very briefly, I think a very related project that Professor Levy has been working on with Professor Clopton at Northwestern, there is no one better to ask about the local rules of courts than Professor Levy. And in a pair of forthcoming papers, you'll learn a lot about what do the local rules actually look like and what does the local rulemaking process look like. So maybe we can get into that more if there's time. Wonderful. Yeah, Professor Meyer.
Oh, great. Thank you for this. So I'm curious, the Federal Circuit suspended one of its members and has been involved in litigation against that member.
The other Judge Newman, not my Judge Newman. It's important to know.
No relation.
Yeah. So I'm just curious, what sort of, it seems like a level of transparency that the federal courts are really not comfortable with or experienced with in dealing with sort of exactly, part of that suspension, as I understand it, involved just not getting opinions out and those kinds of things.
Yeah.
And so I'm curious what you sort of think that kind of phenomenon has, if we're likely to see more of that, as you increase transparency, if we're likely to, if it's likely to impact your ability to return to these folks, if in fact now these internal procedures are potentially the subject of litigation, even if the courts ultimately win against their members. Just in general, what do you make of that for your project?
Yeah, so it's a terrific question, and I'm going to try to answer it in a few different ways. So I said before that the chief judges noted one of the most difficult problems that they face is how you get a colleague to get his or her work out on time. The second problem that they noted, though, is how you get older colleagues to leave the bench when it is time. And once again, that is a hard thing to do when you do not really have sticks and carrots at your disposal. So as I'm sure folks will know here, something that makes the federal appellate court special as compared to the Supreme Court is you have the option of taking senior status when you are eligible, right? Meaning that you've been on the court enough years and you are of a certain age, right? That you basically have earned yourself something that's like retirement, where you can still hear cases, but you give up your seat. When you're in that particular status, if you've taken senior status, there's a whole lot that the federal courts can do to essentially make sure that you are doing your work the way you are supposed to. And the main mechanism there is that the chief judge gets to certify, or has to certify every year, that you are doing the work that you were supposed to be doing and at a level that you're supposed to be doing it. And the chief judge can withhold that certification. It's a much harder question when you have someone who just says, like, I'm not taking senior status. So one of the things we heard a lot about in interviews is, like, what are the soft tools that chief judges have, the kind of diplomacy happening behind the scenes? Can you get certain well-respected judges on a court together to try to talk somebody down, basically? Can you encourage judges themselves to make pacts with each other? You know, somebody saying, I'm telling you it's time, and that you've agreed that you're going to listen to that. I think in the larger way, what this really gets to is not even sort of this part of judicial administration, but the larger question of the governance of the judiciary, right? That so much right now really rests within the hands of the judges themselves, and that's obviously facing a lot of scrutiny right now. We're seeing that not just with this issue, but other issues. So the Federal Judicial Center itself just came out with a report that said that the courts have kind of not been really fulfilling their responsibilities when it comes to, like, reporting workplace misconduct. You know, there are things like that that's getting a lot more scrutiny right now. And some of that then starts to move away from the individual courts and gets to things like the Judicial Conference. So that's, of course, the policy-making body of the federal courts made up of chief judges and others, right? That's the role of the Chief Justice weighing in on all of that. So what I would say is, in general, I think just kind of where we are, we're starting to see a lot more scrutiny on these kinds of issues, and it's going to be interesting to see whether the courts will try to give a little bit. We're seeing some of that dance happening right now with the Supreme Court around ethics reform. I mean, you know, if there's enough public pressure, I think you will see some changes. And the fact that there's been this much attention on what's happening with Judge Newman, I think, would suggest we might start to see the courts themselves saying, okay, we're going to change some things because we don't want Congress to tell us what to do.
Dean Abrams.
This is wonderful, Marin, and congratulations on being the new chair of the Faculty Incentives Committee.
I can hand out all the carrots you want. No sticks.
Big basket of carrots.
No sticks.
My question is about access to justice and rules. So you've talked a lot about transparency and how you favor transparency as being good for the public, and you just talked about ethics rules. I'm wondering sort of a third category of which types of rules are better for either unrepresented litigants or litigants who can't afford a lawyer who's able to either know all the details about the inside information about these rules. I was wondering, for example, about oral argument rules and whether the variation, I'm assuming there's variation among oral argument rules, like kind of what way that cuts for you as maybe an example of access to justice-friendly rules.
Yeah, this is such a great question. So as I'm sure folks will know, right, you have a fairly high percentage of appeals before the courts these days that are coming pro se, right? So these are people who are representing themselves. And it may be worth separating those out into two categories. You have folks who are incarcerated who are pro se, and then folks who are not, and they are treated differently by the court. So there's a ton of variation when it comes to how they are treated, right? So there's some circuits that still permit non-incarcerated pro ses to have an oral argument, the Second Circuit being one, but most courts don't. Their view is this is not entirely helpful and we should just save the resources. So my own view actually with this is, I mean, part of this is how you make your information available, right? So do you have a website that's easy to use? Do you have special rules for pro ses? So there's some circuits that do in ways that are not even so much about making it clear what you need to do, but actually providing additional resources for people who aren't showing up with an attorney. So there are a couple of circuits where they relax their rules around briefing. So the federal rules of appellate procedure have a number of rules about what briefs need to contain. They're pretty extensive. There are a few circuits that say we just relax that entirely if you're pro se, right? You just need to give a short statement of the facts and what you're arguing, right? And we're going to work with you from there. There are other courts that don't do that, but that say, like the Fifth Circuit will loan out a brief to somebody who's pro se. Like, we're going to give you additional tools to try to help yourself. One thing that I think is important in the background is that it used to be the case that there were staff attorney offices that were dedicated to helping folks who were filing pro se. Over time, as the caseload increased, staff attorneys shifted kind of away from that and more to helping the courts themselves by preparing things like summary orders, these sort of short orders that get sent out. I would actually like to see the return to more resources to helping pro ses, right? So even if you have more norms or you have rules that are written somewhere, I think actually what's really helpful is having points of contact at the court, right? And people who will work with you and help you with what you're filing, and showing you this is what, a kind of brief would look like for you. I think that is really what would make much more of a difference. It would be nice to see more of a return to that.
Wonderful. In the back, maybe, do you mind saying your name?
Yeah, hi, I'm Maya, I'm a 1L. Thank you so much for speaking with us.
Sure.
I'm curious if judges are internally consistent with the process by which they determine a rule is necessary. And once they have done that, do they have a process of navigating the available options for how they determine the rule that they want? Is that internally consistent for them, or is there a variety within them?
So this is great. So you're thinking about, so like when a judge might propose that there be a new rule on something like that, are they internally consistent? So that's a terrific question, and I don't have an answer to that. I think for something like that, I'd really want more data on kind of who has proposed what rules in the past and when have they seen a need for that. From these interviews, it is clear that there are certain folks on each court who are kind of known as the, you can put the, rules guru or perhaps a rules nerd, depending on who is putting the label on. There are people who are more invested in this sort of thing, the kind of machinery of the courts, and they are more likely typically to be proposing things and to be on the rules committees, like just at the outset. So whether folks are kind of consistent about that, I'm not sure. But I also don't really know what consistent would mean necessarily, right? I mean, we're talking about such different areas. It's hard to say, you didn't identify a need here, but you did there, and that's inconsistent, as opposed to just maybe that person really thought that there's something quite different about the context here that would call for a rule. But it's a great question. It'd be one that would be fun to study more.
We're just about out of time. Maybe if I gather maybe two more
Lightning
questions,
round.
would that be okay? Wonderful. Deborah, maybe, and then was there anyone else? And Professor Buckfusco. I apologize. So Deborah and Chris, let's go to that.
Here we are. So looking at the images behind you on the screen,
Yes.
you see the exteriors of just 7
Yes.
courthouses, but I won't go there. Having that in the background made me wonder throughout your discussion how much variation is a function of geography. I mean, so some circuits are notoriously dispersed,
Yes.
others less so, and then not.
Yes.
DC circuit, okay, or space. I mean, kind of like the architecture internal to the courthouse itself. Whether some of those have many floors, others appear to have like 3. Does that make? Do you think that makes a difference in some of what you observe?
Chris, I was going to ask a version of Deborah's question, but I'm going to ask a different one instead. So first, congratulations and thanks for sharing this. This is terrific.
Thank you.
Understandably, we've been talking a lot about variation, and so I guess I want to ask you about perhaps surprising uniformity or consistency. Was there anything from either your perspective or from your participants' perspective that, when you all learned it, you said, wow, it's actually kind of shocking that we all do this the same way, rather than, in fact, quite differently?
This is great. Okay, these are 2 very different questions. I've got about 30 seconds. I'll do my best to answer. On geography, absolutely, and to both of the points that Professor DeMott was making. Right, so we can think about geography in terms of how many states do you cover, across how many time zones, right, that sort of geography. But there's also geography when you're thinking about the courthouse itself, the kind of architecture of it. And I think it's certainly the case. You look at the DC circuit, everybody is in the same building. Right? And they talked about that and how that affects collegiality, the ability to walk down the hall and talk to somebody. And that also, I think, one could imagine ends up with, say, more norms and customs potentially than rules. It would be interesting to drill down on that a little bit more. That's certainly what Zach Clopton and I have found when it comes to district courts, right? You hear judges talking about we share the same hallway and we basically just come up with our own practices together. We don't need to put this in terms of court rules. So I think absolutely that ends up having a number of effects on the procedures of the courts in really important ways. And I think even potentially on the outcomes of cases. Right? In terms of consistency, so I can't think of any particular example where we were really shocked and we thought, wow, like all 13 just happened to line up. But maybe I'll put it in this sort of way, just as to kind of end on. It is remarkable, right, to think about how we have these 13 very different institutions, but all engaged in essentially the same business, right? They're all trying to decide appeals, right? They're all trying to apply roughly the same law to difficult legal questions, most of them, or some of them difficult, right? And get them out. And that's a shared enterprise. And so, when it comes to the fundamentals, we're seeing these across the courts. Briefs come in, we hope they're read, right? There's argument, sometimes there's not, right? There's an opinion. Like that whole apparatus is operating across all of these courts. And in some ways, maybe that's the remarkable part, right? That we actually do see this shared enterprise and that we don't even have kind of more variation than we do.
Wonderful. Thank you all for joining me. Please join me one more time in congratulating Professor Levy on this remarkable